Good afternoon, all, especially honorable judges from the Madras High Court, honorable judges of the subordinate judiciary, all the senior counsels, and my beloved younger members of the bar to whom the webinar series is dedicated. Justice Kurian Joseph started his career in law in the year 1979 at the Kerala High Court. He was appointed as the AAG of the Kerala High Court, and he was designated as the senior advocate by the Kerala High Court. And in the year 1996, in 2000, Justice Kurian Joseph was elevated to Kerala High Court as a permanent judge. Justice Kurian Joseph was also serving the Kerala High Court as the acting Chief Justice. Thereafter, he was appointed as the Chief Justice of High Court of Himachal Pradesh in the year 2010. In the year 2013, Justice Kurian Joseph was elevated to the Supreme Court of India. He retired from the office of Judgeship of Supreme Court of India in November 2019. During his tenure at the Kerala High Court, Lordship was the chairman of Kerala State Judicial Academy. He also served as the executive chairman of Kerala State Legal Services Authority. He was also a visiting professor at National Law University, Cochin, and he was also a visiting faculty of National Judicial Academy at Bhopal. During his stint of office as the judge of both the High Courts and Supreme Court, Justice Kurian has delivered landmark judgments in multiple numbers that speaks volume of his caliber and knowledge. Lex Webinar Series today is hosting his Golden Jubilee 50th series, and we are delighted to have a very famous and erudite resource person on behalf of Lex Webinar Series and my co-host Hemalatha and the legal fraternity across the country who are connected on the virtual platform. I wholeheartedly welcome Justice Kurian Joseph. Sir, you are welcome and the forum is yours.
Thank you so much, Bhagavan and Hemalatha, the host of this program and this organization for this meaningful program. I am sure some of my esteemed and beloved brother judges are also participating in this. Some of them, including my brother Vaidyanathan, has told me that we'll meet in the evening. So I'm sure some of them are there, both present and past also. And my dear esteemed and beloved sisters and brothers from our family of what they call the justice dispensation system. It's indeed a great pleasure for me and a privilege also to address you on this 50th lecture session. But this is something which was not known to me that this is 50th. So this is a golden jubilee. And I'm happy at least you thought of me on the 50th. I'm sure you will be waiting for a special occasion for me. So, yeah, Brother Justice Vaidyanathan is already there. Yeah.
Yes, he has joined me now.
Yeah. So thank you very much, my dear sisters and brothers, for this great opportunity. I'm happy that you have chosen to utilize this great opportunity, the time that God gave us in this pandemic for creative purposes and actually for sharpening our or updating our legal knowledge. I always used to share this parable of pencil. You know, pencil is meant for use. But if you want to use the pencil properly, you need to continue to sharpen it. Yeah, it's a painful thing for the pencil. It will think something is being chipped away. But chipped away for what? Chipped away only for making the best use of it. So for us, if we spare some time or take some effort in updating our knowledge, it is actually helping us. And for the best utilization of the call that we have received to be the spokesperson of the people in court, and to be part of the justice delivery system. When we think about the justice delivery system, I always say the lawyers are also integral part of it. Because court is not a room, or it's not a building or an institution. It's a service. In the service, there are various duty holders. Stakeholders are only the litigants, according to me. We are all the duty holders, the judges, the lawyers, the officers of the court, and all those who help us to make this service possible and effective and expeditious are part of this service. So this is a new normal coming, that instead of people coming to court, the court is now going to people. That is the new normal post pandemic. There is a new jurisprudence coming, according to me. Access to justice has become faster, more effective, and more transparent, because it is now 100% transparent. What is taking place in court is not only recorded, but it is visibly, ocular visibility is also there. So therefore, somebody was remarking the quality of lawyering also has improved. You can simply say something in court and escape. No, because your client is watching you, wondering what are you performing in court. And for us judges also, sometimes we can't hear always a second appeal. We used to say in South, when you hear a second appeal, after some time you get bored and start those things. Now we'll be very careful. Judges also from our part, will also be very careful, because we are being watched, not only by the people inside the courtroom, but being an institution. Now it is across the world. Anybody from across the world can watch you. Though it is still not open, the videography is still not coming up, but I think the steps are to that effect. But in any case, it is in the digital world. Even if it is permitted, accessible only to the permitted people who are taken the permission to participate in the court proceedings, still it is recorded, a digitalized version. There is a record of what has actually happened. It can anytime be retrieved also, it can anytime also. So it goes on record. It's simply on record means it is not when you write, but it is visibly recorded. So it has, according to me, it has enhanced the quality of the justice delivery system, from the side of the judges, from the side of the lawyers, from the side of the staff, from the side of the expediency, effectiveness, and whatnot.
May I add only one thing, Miller?
Yeah.
In Madurai bench, in the cost list, they print the Cisco WebEx user ID as well as the password. So anyone can have access to the video conferencing and see what is.
Wonderful, wonderful. That's why I said, otherwise you needed a pass to enter a courtroom. You don't require a pass. You need only a gadget with you. You can come in now. So that is why I said it has become more transparent. This is actually the God-given opportunity for the court to be transparent. You did not require a PIL to be filed for videography. Now the PIL has been filed from above. Judgment also has come. No judgment from the court, but the judgment from the upper court. Melendu vandachu. Exactly.
Very nice.
That's very good. It's good. I always love it. If we can, telecast the proceedings in the parliament or in the assembly, why not? What is happening? Except, of course, the caveat is there, the in-camera proceedings, where you have a right to have your privacy. So, except in camera, everything else should be camera. Everything else should be visible. Everybody. What's wrong with that? In many countries, it is visible. We can see the great arguments taking place. And there is a new normal also coming. Good that I share also. This is a brief introduction. See, if it is a matter of final hearing, you can present your arguments in a pre-recorded video and send to the other side and send to the court. And the other side also can send their reply in a pre-recorded video to this side and to the court also. And the petitioner gets a rebuttal video also. There are 3 videos, rest you can leave to the court. So it has become leave to the court, so it will become very quicker, very, more expeditious. So that, the judge also saves time, you also save time, you get, there is no interference, there is no question of a court taking the hammer, asking them to keep quiet, etc. No interference at all. You have full concentration, you can sit in your room, prepare the whole arguments, present it in a video, and you can limit your time also. No? Court will say you complete your arguments in a video recorded for maybe say half an hour, say 45 minutes, say take 1 hour. Only when you are in performance, actual performance in court, the interference comes, distractions come, and it takes longer time. But in a pre-recorded final hearing arguments, this is something which somebody should test. And this is being tested in arbitration. Since I'm doing my arbitration now and mediation now, I test this in arbitration. It's actually effectively working. Because you don't require the physical, exchange or presence in the matter of arguments in final arguments in arbitration system. So likewise, when you argue appeals, I don't think the visibility of the other side is required, because your arguments are presented in one video, reply comes, rebuttal comes. You get an opportunity, nothing is lost, and nobody is adversely affected also. So with this introduction, let me come to the constitutional value. In fact, this is also a constitutional value. Access to justice and speedy justice and quality justice. This is also a constitutional value. But when we speak about the constitutional value, it comes from the Constitution. So what is this Constitution? This Constitution is our Constitution. This Constitution is, my brother Nagamuthu is also seen.
Yes, no, he's here.
Malay Vanakkam, yeah. Yeah, so it comes from the Constitution. Whose Constitution? Our Constitution. For whom? For us. Who are we? Our country. So it's a Constitution of our country. We, the people of India, having resolved to constitute it. So who constituted this country? We constituted. It's my country. It's my country. And I am part of this country. So it is our Constitution. Justice Krishna has written beautifully on this, we the people. Yeah, but we the people of India having solemnly resolved to constitute. So we first constituted India, and then we thought of providing it with a written constitution, defining what the country is. So we defined the country on 5 cornerstones, or rather 5 foundation stones. I must say foundation stones. 5 basic stones. What are Adhisthana Shilai? We call it the basic, yes. On these foundation stones, 5 foundation stones. That is, India is a sovereign. India is a socialist. India is a secular. India is democratic. India is republic. So we have 5 stones. We are building I'm just taking you to a construction. You can just think of a construction. We are going to build a house now. So 5 stones we have put. In fact, it was not told to us that there are 5 stones. What we were originally told when this building was constructed, there are only 3 stones. 2 stones were not told. Those 2 stones are a socialist and a secularist. And these 2 were not actually told. Why were they not told? I used to simply joke at people and say, I don't require something on my forehead to say I'm a man. I'm a man. So why should I tell I'm a man? So India is a socialist country. India is a secularist country. It was not felt necessary to be told explicitly. But having lived our constitution for 25 years, in emergency, in the report of Soren Singh committee, it was felt necessary that it is better to tell that there are 2 more foundation stones also, not only for the people living in this country, but for people across the world to know that ours is a country which is secular and democratic. Because socialist. Secular and socialist are actually there in the constitution. Because preamble is actually a summary of what is actually there. It's a prelude of actually what is there in the constitution already. So in 75 and the 42nd amendment, these 2 stones were also revealed that is there already there. So now we have 5 cornerstones, 5 foundation stones. On these, what are these 5 foundation stones? Let me complete the structure first. On these 5 foundation stones, we have 4 pillars. So it is actually a stupa building on 5 stones. 4 pillars. Those pillars are: 1, justice; the other is liberty; 3rd is equality; 4th is fraternity. So 5 foundation stones, 4 pillars coming. Yeah. On all 4 pillars, there are sub-pillars. So take the first pillar of justice. We have 3 sub-pillars. It is socio-economic and political. So justice, social, economic, and political. That's a sub-pillar. Take liberty. Liberty, we have 5 sub-pillars. It comes like this, 5. Liberty of thought, expression, faith, belief, worship. So 5 are there. Take equality. 2 are there. Status and opportunity. Now that's promoting what? Fraternity. Fraternity also has pillars. Fraternity assuring the dignity of the individual and securing the sovereignty and integrity of the country. There are 2 pillars for that also. So this is actually a constitution of this great country where we have 29 minus 1, 28 states as of now, 7 union territories, 22 scheduled languages, 844 dialects, thousands of unscheduled dialects or dialects without scripts, a country with all world non-religions, a country which is predominantly the communities of Hindus, but it has welcomed all non-religions. It welcomed Christianity, it welcomed Islam, it welcomed the Parsi, it gave birth to Buddhism, it gave birth to Jainism, it gave birth to Sikhism. So it is a country where you have a what they call the original principle of Vasudhaiva Kutumbakam is actually practiced. Nobody is bothered about one's own religion. Everybody says, somebody, because let me touch that aspect first. I'm taking the first one of the founders and sons because that there's a lot of things now being said or discussed about this issue, secularism, and that's a touching sickness. What is the unique beauty of Indian secularism? The unique beauty of Indian secularism is that this country does not belong to any religion. Number one, the state does not have a religion. And this country also does not belong to any religion. This country does not have any special treatment for any religion. This country welcomes all religions. This country recognizes and acknowledges the role the religion can play in molding the character of a person. This country permits a person not to believe in a religion. This country permits a person, if he believes in a religion, to practice it, to profess it, to practice it, to propagate it. This country permits that these 3 aspects in his freedom of conscience. It doesn't say freedom of religion. Article 25 doesn't say freedom of religion because religion is a freedom of choice of a person. That's why it's called freedom of conscience. So one can be a Christian today, tomorrow he can be a Hindu, day after tomorrow he can be Islam, a Muslim, 4th day he can be a Buddhist, 5th day he can be a Jainist, 6th day he can be a Zoroastrian, 7th day he can be an atheist. This country permits anything, provided he has made his own conscious choice out of his free will. It's not out of any allurement, it's not out of any duress, it's not out of any compulsion. Yeah, it should be one's own choice. If I make a choice, nobody can stop me from embracing any religion. Because it is a religion is a matter of personal choice of a person. Even the states where some regulations or some legislations have been made with regard to conversion, etc. See, conversion is one thing and exercise of freedom of conscience is one thing. Conversion is somebody converting somebody. That doesn't mean that I cannot convert myself. I can convert myself to be an atheist. I'm an ardent believer in my own religion, Christianity. Tomorrow, my freedom of conscience permits me, I can choose to be an atheist. I can choose to be a Hindu. I can choose to be a Muslim. But it should be my own freedom of conscience and my own conviction. Not because somebody has given me something, not because somebody has threatened me with something, neither fear nor favor. So that is the freedom of conscience. When you say conscience, that means you have taken a conscious decision. That conscience does not mean that your sense of right and wrong, it doesn't deal in this aspect of the moral principle, but it means an informed, conscious decision that you are taking. If you are taking such a decision, nobody can prevent you from converting yourself, from departing, going from one religion and going to another religion, ceasing to be in any religion, whatever it is. But that is subject to four, let me complete that aspect, that is subject to four caveats. One, that exercise of freedom of conscience and by practice and propagation is subject to public order, health, morality, and the fundamental rights, other than Article 25. That means the other provisions of Part 3. So only these four restrictions are there. So subject to public order, health, morality, and other provisions in Part 3, any citizen of this country can believe in a religion, not believe in a religion. If he believes, he can practice, he can believe, he can practice, and he can propagate. That is a freedom given to them. I don't think there's any country in the world where you have such an omnibus concept on secularism, where you are given such a vast liberty. That liberty is, that liberty is freedom of thought, expression, faith, belief, and worship. See the preamble. That liberty has three aspects: faith, belief, and worship. Your faith, belief, and worship is your own liberty. I saw the question in the chat box. I'll deal with it. Forced conversion is definitely wrong. I endorse it fully. Nobody can force you to convert or reconvert. Nobody can do it. It should be left to the individual's choice. Once the individual has taken a conscious decision, nobody can prevent it. Either converting, reconverting, or going for another religion, whatever it is, or choosing to be atheist also. Why worry about religion? He can be atheism is also another religion. Religion means his conviction. So that is the beauty of this country. But unfortunately, this is not perceived to be in the correct context and in this correct value-based basis. This is the whole problem. So there's a perception that secularism is not understood on the correct constitutional foundations. If this is not understood, so whole problem with regard to India is we have all the religions here, and people are highly religious also. So anything that touching on the religiosity of a person becomes a very sensitive issue in the country. That is now let me come to democracy. The beauty of what is democracy? According to me, my simplest definition of democracy is that every citizen has a space in this country, and all citizens have a voice in this country. This is democracy according to me. We have learned in our school that this is a government of the people, by the people, for the people. But according to me, democracy is, I have a space in my country. Yes, and I have a voice in my country. Nobody can suppress my voice. Nobody can deny my space. My space is secured. My voice is also protected. One is a secure space and the other is a protected privilege of my voice. This is democracy. So my practice, my profession of faith, my practice of my religion, and my propagation of my religion, subject to only those constitutional safeguards under Article 25, is permitted in the Constitution, which is a secular country. And this secular country is a country where secularism means that it welcomes the role the religion can play in molding the character of a person, making him a better citizen, more responsible citizen. That is why India welcomed all religions. India permitted religions to take birth in this country. And India has recognized the fundamental right of a person to practice, profess, practice, and propagate any religion. So that is secularism, and that is democracy. And socialist, it is opposed to capitalism. I don't have to speak to the lawyers on this issue. What is socialism? And what is sovereignty also, we don't have to say, but we have to say something about it because our sovereignty is now threatened. all our neighbors are hand in glove, it appears, from all sides. We are going to face a very difficult music, according to me. So our sovereignty, that we are not under anybody, and we will not permit anybody to have a say in our own affairs also. That is our sovereignty. And it's republic. Republic means you and I can become the president of India. I always say in the republic, the most beautiful part of the republic is that if you are qualified to be elected as a member of the parliament, you can become the president of India as well. It does not make any difference at all. Now come to the equality of status and opportunity, equal protection of laws, and equality before law. And let me club it with, because after equality comes thus promoting fraternity. And fraternity, it comes in a dignity of individual. There's no constitution in the world which has given that much of value to the dignity of the individual in this country. And when I say individual, just keep in mind, there are two articles, Article 14 and 21. They are the part of the fundamental, they are not limited to the citizens. They are limited to non-citizens also. A foreigner is entitled to have his equality and dignity protected in this country. A foreigner is entitled to have his life and liberty protected in this country under Article 21. All other articles are available only to the citizens under the Fundamental Rights Chapter Part 3. But whereas this Article 14 and Article 21 are available to the non-citizens as well. Life and liberty of any individual. And that life and, when we say life and liberty, it comes dignity also. That's actually right to life means right to lead a dignified life. That's a dignity. Dignity of the individual is highly respected in this country. There's no country in the world which respects and protects dignity of life as India does. That is the beauty of our constitutional value on equality and fraternity. And that is why, let me just touch on that constitutional morality also. What is this constitutional morality? It's not something special morality, but constitutional morality lies in three aspects. One, it is in the aspect of liberty, in fraternity, and dignity. If your liberty as far as faith, belief, and worship, thought and expression, and your equality, that you are equal before law and your equal opportunity available to you as a citizen of this country, and the dignity as an individual is protected. So that is actually being discussed, that was discussed in Puttaswamy in that, what they call privacy issue. Privacy. Yeah, and that is now being discussed in the Sabarimala issue also. This constitutional morality is a matter of big discussion that is yet to come. So let's not go with that aspect also. How far this dignity aspect, how far the religion, how far your right to profess and practice religion, etc., come into whether there's any conflict with these rights inter se, and whether this what they call our constitution's integrality as such is conceived and protected in the matter of faith and worship, etc. All these are some of the questions which are going to come. But I tell you, with all the differences in this country, I spoke to you about the number of religions, the number of states, the number of languages, the number of what they call union territories, and the number of people. I didn't say something about the number of people. We have 134 crore people in this country, of which 120 crores use mobile phones. I'm officially quoting these statistics. So see, our literacy, internet literacy is that high, except for people that who are not able to follow this internet. All others, what you call this gadget language, all others are using it. So except our little children or except those people who do not know anything about it, all others are using it. And you think about the what you call the different languages, different cultures, different religions, different styles of dress, different food habits. Even in Tamil Nadu, take one part of Tamil Nadu and another part of Tamil Nadu. What they call the dialect in Tamil itself is different from one part to the other. Your food habit is different from one part to the other. Your style of dress is different from one part to the other. Take our neighbor. I come from your neighbor state, Kerala. It's one of the small states. The language I speak in Trivandrum is not what I speak in Kottayam. Center Trangur. That is not the next district, Trichur. It's different. When I go to Calicut, it is different. When I go to Kannur, it is different. Same Malayalam. different. The food I eat in Trivandrum is not the food I eat in Kottayam. That is not the taste I see in Ernakulam. That is not the taste in Trichur. That is not the taste in Calicut. That is not the taste in Kannur. The way I dress up, the dress, what you call the popular concept, the dress of men and women in Trivandrum is different in Central Trivandrum. It is different in Malabar. So that is the variety. That is the what you call the pluralism. It's not pluralism. That's actually the diversity. Yes,
Diversity.
Yes, diversity we see, in one state. And I was Chief Justice in Hemalatha. There are 12 states there. 12 districts there. Each district has a dialect. Similarly, next one is next district, I forgot, Solan. It's a Soloni. Every district has its own dialect. Yet it is Himachal Pradesh. It is 5 times bigger than Kerala. But it has only 1/5 of the population of Kerala. That's a different aspect. But I'm saying, so you travel from your south to, we have something in common in south, but you just travel towards the north. Now Nagamuthu is in north. Just travel from the south to north. The types of differences one can feel. With all this diversity, India is India and there's only one India. Why? Only reason is we have such a wonderful constitution. A constitution which has secured the space of everybody. A constitution which has protected the voice of everybody. That's the only reason why India is India, because it has webbed us all together. Webbed us all together into one country, one nation. That's the beauty of it. Why it is so? Because the fundamental value of this constitution is that there is no difference, no different treatment to any citizen of this country on account of his religion, on account of his language, on account of his region, on account of his sex, on account of his place of birth, on account of his position, on account of his money, on account of his power, on account of his possessions. No, makes no difference at all. Only one thing matters. Are you a citizen of this country? Yes. You may be black, you may be white, you may be short, you may be long, you may be male, you may be a female, you may be a transgender, you may have you may not have any single inch of land that you possess, you may not have a house, you may belong to this caste, you may belong to that tribe, you may belong to this class. It makes no difference at all. All tribes, all castes, all communities, all are equal before law. What matters is only that you are an Indian. That's why 12 years in the school we take a pledge. What is that pledge? India is my country. All Indians are my
brothers and sisters.
Brothers and sisters. This comes from this constitution. But unfortunately, that remained only in the head. It did not travel to the heart. The whole problem with regard to this country, the threat I perceive in this country are only 3 C's. 3 C. One is casteism, second is communalism, third is corruption. 3 C's. Casteism, communalism, corruption. Although we have a beautiful constitution with beautiful values and and a very powerful judiciary where these values are supposed to be protected, are bound to be protected. Yet, with all that, the people have a perception that, I am a lesser citizen of this country. Some people view me that I am not as equal as a citizen as he is. He treats me as a lesser citizen, and he treats himself as a better citizen or a higher citizen. Well, that is the whole problem. The constitution protected, but attitudes did not change. This is what Dr. Ambedkar said. The constitution is very good, but if it goes into bad hands, nobody can save it. Even if constitution is bad, if it goes to good hands, the country will be saved. So it's a time for introspection to all of us. It is in the working of the constitution that the values have lost, if at all. glory, its what they call that aura. The aura of the constitutional values actually is perceived to be affected because because of these three: casteism, communalism, and corruption. We are not able to think above all these three. We are still thinking as to who belongs to this caste, this tribe, this community, that community, speaks this language, this religion, that religion, this money, that wealth, this position, this region, this gender. Yeah, so it is in principle, everything is there. But unfortunately, in practice, we have not learned to practice the Constitution. To live the Constitution through its values has been a difficult task for the last more than 70 years for India. India has not been the constitutional India so far. So the challenge before us, particularly the lawyers fraternity and the judicial fraternity, is to redefine the Constitution the way the constitutional life has to be seen, reflected in the ordinary life of ordinary man. Whether he belongs to a sub-caste, whether he belongs to a downtrodden caste, whatever it is, So irrespective of caste, color, creed, religion, sex, language, region, we should be seen as India is my country is a great country, and all Indians are my brothers and sisters. I'm looking forward to a dawn or a day where this country treats everybody, all constitutional institutions treat everybody irrespective of somebody belongs to a religion, a caste, a community, speaks a language, belongs to a region, belongs to a particular sex, whatever it is. No, irrespective of all this, we are all bound to be treated as Indians. As Indians, we are one. Then we belong to the country. Then we will define our country as a nation which we have constituted to ourselves to be one nation. That is the greatest challenge before us. It is this challenge every day we have to respond to. Hopefully, the lawman community who know law or who are supposed to know law will be in a position to address some of these concerns, and we will take our country to the soaring heights which our founding fathers dreamt of it as a great country, a unity in diversity. Thank you so much, probably I should devote some time for our interactions also. I'm sure I'm not dealt with everything, but I've given you sufficient food for thought food for thought.
I would rather say that the take-home message on the 50th series of the lecture is something very thought-provoking, very simple but power-packed. So for a person who has the root in the Constitution of India, and every Indian should take home the message, Millard, then they should live up to the expectation of the country, because it is the Constitution that we gave to ourselves. I hope your Lordship's lecture will instill and imbibe the confidence and the need for keeping the principles of the Constitution abreast in their mind. Now let me move to the first question. Mrs. Narmada Sampath, Additional Advocate General of Madras High Court, wants to pose the question.
So I thought probably you'll be touching upon the practice of capital punishment and the purpose.
Oh, you want me to touch that? Shall we have a webinar on that?
I thought probably, which is very close to your heart, I thought probably you would.
Yeah, it is close to my heart. You just give me 1 hour, I can just speak on that.
So we would be very proud to have it on special occasions, if your Lordship permits.
I think, since we are now confined to constitutional values, we can have on death penalty, on Article 21 and death penalty. It needs to be discussed in this country.
Yes.
Why there is a penalty of death? I'll give you some food for thought also, now that you just asked me to speak on it. Why is there death penalty? Number one. Why it has been upheld by the Constitutional Bench in Bachchan Singh? Number two. Number three, whether the Bachchan Singh after 40 years, now it is the Ruby Jubilee of Bachchan Singh. 40 years of Bachchan Singh has the sentencing down up to the Chanula. Last was mine is Chanula. It has actually been what they call it followed in the true spirit, either in the matter of rarest of rare cases, and whether the what they call aggravating and mitigating factors, and in the socio-economic factors being taken into consideration in the matter of convictions and in the matter of giving them a chance to improve. All these are sufficient food for thought. I think good that we should have something to discuss on this, particularly since we are now celebrating the 40 years of Bachchan Singh. I tell you, we need to discuss about it. I will be very happy to be part of your next webinar when you plan something about web penalty.
It was such a wonderful empirical approach towards the
death penalty. What, Nirmala?
I just stated that it was such an empirical approach towards the entire constitution, right from the foundation to the pillars. It was very, very nice. Thank you, sir, for rendering such a brilliant speech.
Thank you, Nirmala. I always feel, if at least 10 of our lawyers keep in our mind that, there is no difference in my court, in my home, in my state, in my district, in my ward, in my panchayat, between this caste and that caste, this class and that class, this position, that position, all are my brothers and sisters. This country will definitely improve. Our state will improve, our district will improve, our court will improve. Now, in the heart of us, somewhere in the bottom of our mind, comes all this unnecessary, what you call in constitution, we say, irrelevant factors. In Article 49, we learned, you have to eschew irrelevant factors and you have to take only relevant factors. The only relevant factor is whether you are Indian. But unfortunately, we have all other irrelevant factors coming, creeping when you think about defining the status, defining the relationship, defining the space of a person in the country. In actually understanding and acknowledging the space of a person in my state, in my panchayat, in my village, in my court, none of these irrelevant factors should come in. We must make a conscious effort to eschew all this and treat all others as brothers and sisters.
Thank you, sir.
May I request Justice Nagamothu to interact with Chief? Sir, you are welcome, sir.
Yes, brother. But I got two things to mention, and I'm requesting your Lordship to make comments on that. And the Lordship has said about the justice as one of the pillars. Now, may I request your Lordship to identify some of the major challenges that this country is facing constitutionally? One. Two, my lords. In my perception, one of the major challenges that the judiciary is facing is the pendency. The Supreme Court, your Lordship knows, 50,000 cases are pending. In the high courts, for 20 years, we are not able to dispose of both criminal and civil cases. Is it not an injustice caused to the people? What is your Lordship's comment on that? And what are the what is the thought process going on in the Honorable Supreme Court and with the government to reduce the pendency and to assure to the people speedy justice?
Yeah, thank you, Nagamothu, my very good friend, whom I had an opportunity to be part as a brothers, and I had an opportunity to listen as a judge in the Supreme Court. When he started practice, I was there. So that way, and we are now actually doing arbitrations also together. So that's all. In all the three spheres we are together. Yeah, he asked me what is the other challenges in the country. I tell you, let us not mince words. Some of the constitutional values are perceived to be under threat. That's one problem. Some of the constitutional values are perceived to be under threat. Number one. Number two, let me come to the judiciary. The perceived threat is the independence of the judiciary. Independence of the judiciary, we will have to see vis-a-vis independent judiciary versus committed judiciary. See, this is how, I'm sure all of us are lawyers, So you will say, oh, that is a convicting judge. He is a compassionate judge. He is a judge who listens. He is a judge, he is more prone to acquittal. He is a landlord judge. is a tenant judge. Now, all these are notions. Why the people get such notions? If you are truly independent, that's why when people used to say on my face, compassionate judge, I don't feel flattered because it's not my charity. I spoke in my speech also on the last day. See, this compassion is not the charity of a judge. It is the constitutional right of the citizen. The judiciary should have a compassionate approach. And what is that compassion? It's not the charity of the judge. It's a constitutional compassion on liberty, on equality, on fraternity, on dignity. That is the way it should be seen. It's not something special to Kurian Joseph. No, not at all. It is actually the constitutional right that we are protecting. The judge is protected. So no person comes to court for begging. May it please your, we beg to submit. I have felt always embarrassed when we hear, say you will enjoy, of course, being called honor, lordship, etc. There is no problem. But we beg to submit. Why do you beg? You don't have to beg. It's not a begging. You're not begging because the Constitution does not conceive of any begging from the court. Constitution only has conceived of protection of your rights under the Constitution. Protection of your dignity in the court. That's why your dignity is very sacred in the court or in the country. Therefore, the challenge of the judiciary is actually it should be independent and it should be seen as independent also, as opposed to committed. The perception, because see, this institution exists and survives on the faith of the people. Once that faith is shaken, nobody will go to court. They will take recourse to extra constitutional remedies. That is lost. This institution had withstood. The moment its credibility is shaken on account of your perceived bias, maybe it on account of religion, maybe it on account of language, maybe it is on account of your caste, maybe on account of your philosophy, maybe on account of a political ideology, whatever it is. Any sort of bias that the judge is perceived to be is actually a big threat to the independence of judiciary. That shakes the confidence of the people in judiciary. And the moment that faith is shaken, democracy is gone. There is no democracy, there is no country, there is no India. It is some other country. India is India only because this guardian of the Constitution has been vigilant to see that the Constitution is not watered down. But for this guardian of the Constitution, the democracy would have long gone. But the Constitution has been preserved and protected by this guardian of the Constitution, namely the superior courts, the Supreme Court and the high courts. That's the beauty of it. And the pendency. Nagamuthu, I tell you, from my experience, you also have seen in Supreme Court, you take away these criminal cases, but half of the, not even half, not only half, maybe 2/3 of the civil cases in the Supreme Court are worth trying for a conciliation or a mediation or an arbitration. All those, only maybe one-fourth of the cases require a constitutional interpretation on the civil side. All the civil appeals, you can try corporate disputes, your financial, disputes on your quantum of the entitlement of money, your property disputes, your matrimonial disputes. People always say mediation means only matrimonial disputes. Wrong. It's a wrong concept. Mediation in matrimonial disputes is only one aspect. But in all corporate disputes, all disputes relating to money, all disputes relating to property, all disputes relating to your interpersonal rights, etc., all are something which can be taken. So if you want to save the country from the long pendency, the only way is, the lawyer's mindset should change. You don't require anybody's pressure, but the people's mindset also should change according to me. People should pay the lawyer fee more for settling a case rather than arguing a case. But people think that, no, you are not argued my case, why should I give you fees? That mindset should change. Even when a person comes to you with a Section 80 notice to prepare a reply, you can call your friend who has sent that notice. Even before that, you must speak to the client. Are you? Do you really want to go to court and waste your whole life and next generation also in court, or do you want this case to be settled? If you want this solution, I can try. I can speak to the friend. This is your case. This is your problem. I can speak to your friend. We can find a solution. What prevents you from doing that? Speak to the client, settle your fees, and then take steps to speak to your client, speak to the lawyer, and then sit together. Save the parties from going to the court. Number one. Number two, in respect of cases pending in court, what prevents you, unless you are so keen to have a daily appearance fee. To me, I feel the daily appearance fee in any court is an injustice done to the client. In my whole career as a lawyer in almost 21 years, I never ever charged any client for my daily appearance. And of the 5 people appointed in the batch, when I became a judge in 2000, I was the highest income tax payer also. I'm not boasting, but I'm saying some facts. I never ever had any problem in settling my fees. I never ever charged a client in advance. I never fixed my fee in advance. I always handled my case and asked the parties, except in the case with the Marwadi, which there's a different reason because his attitude was different. Therefore, he made me to fix his fee first. He was not concerned about the ultimate result of his case. He was only bothered about the fees he has to pay. So we had to fix it. Otherwise, I always left it to the parties to pay. And in the majority of the cases, they have paid me more than what I desired. And in only very few cases, I got a less fee. And I've done so many pro bono cases also. I have no problem. See, money is not the issue. So therefore, if the mindset of the lawyers, so in the pending matters, you call the party and say, the way the things are going now, particularly you can say pandemic reason also now, it is not going to see the light of the day. I think this is in your interest to take the matter out of the court. And, if you permit, I can speak to the other side lawyer also, and we can get the parties and try either an arbitration or a mediation or a conciliation and see a finality. But that does not mean that you don't pay my fee. You have to pay my fee. This is my fee. You pay my fees. We will make an attempt. If it succeeds, you pay the fee. Otherwise, we can leave it to the court also. So that attempt should be made by the lawyers. So at least if you make these 2 simple steps, either for preventing parties from going to court and helping parties to get out of the court at the earliest. If the lawyers and the litigants' mindset should change, lawyers' mindset should also change. Then this is the only way, according to me, you can address. After all, we know what is the merit and demerit of a case. Does any lawyer, is there any lawyer who does not know the strength and weakness of his case? He knows. Is there any client who does not know what is the truth? He knows what is the truth. So helping the party to accept the truth and make both parties happy in mediation or conciliation is a wonderful step. Probably you should try to reduce the penalties and take people out of the court.
No, thank you, Lordship. I think that I go probed your Lordship on the question of independence of the judiciary. Thank you, Lordship. And your Lordship has not said anything about the criminal cases, Lordship, pending for years.
Yeah, criminal case, I agree, Nagamuthu, criminal case should be fast-tracked. That's why I said in criminal appeals.
Yeah.
Let's take criminal appeals first. What prevents you from arguing the criminal appeal the way I suggested you? You make your arguments in video and send it to the court and share it with the other side. And the other side also shares his arguments, puts forward his arguments, and you get, as an appellant's counsel, to put your rebuttal in the video and leave it to the court. Let the court write it. A judge is a 24/7 judge. Pardon me, Vaidya, I'm saying he is also a faster judge than me also. I always boasted myself to be a fast judge because I didn't believe in keeping any judgment pending. I was a fast bowler that way. So I think the judges also, they just spend more time in particularly High Court and Supreme Court times. So they spend more time at home in deliberating on the judgment and writing judgment than the time they sit in the court. People only know that they have lot many vacations. if they had not have that much vacation, they would have been in mental asylum, according to me. Because this is you people argue, leave it to the court, no? Now the burden comes only to the judge. The judgment goes bad. Nobody will criticize the lawyer who argued. People only say that. Nonsense. He does not know ABCD of the law. He is a lazy judge. He is a crazy judge. He doesn't bother. He writes something. He outsources. You will say whatever you want to say. Therefore, a true conscientious judge, according to me, is a 24/7 judge. And only if he is not a 24/7 judge, according to me, he is not a judge.
Thank you,
May I request Justice Vaidyanathan to interact with you.
Good evening, sir.
My dear brother, good evening. How are you?
Fine, sir, fine. Nice to hear your voice. See, you have narrated in nutshell, and everybody should listen. Those who are not participants today, they should go to the YouTube and listen to this lecture, and it will be very, very useful to them. I have no questions to ask you.
Thank you, my dear brother. Thank you.
And in fact, you have given a detailed answer to a question posed by Justice Nagamuthu. Thank you very much, sir.
Thank you.
Yes, my lord, for the excellent session.
I'm only happy to be with the lawyers. Any time I get an opportunity to be with the lawyers, I'm only very happy. Subject to of course, my little bread butter training now. Now I'm also practicing a profession now.
Yes, my lord. Thanks a lot, my lord, for your time and energy.
Thank you. All the best, and God bless you. Jai Hind.